I have been tracking firearm law implementation long enough to recognize when rights exist on paper but remain invisible in practice. For Americans over the age of 60, there are 10 categories of legal protections and advantages embedded in federal and state firearm statutes that most people in that demographic have never been informed about. These are not obscure loopholes. These are codified rights and exemptions that exist because legislators recognize that older citizens face specific circumstances that warrant different treatment under the law. But if you do not know these rights exist, you cannot exercise them. And if you cannot exercise them, they provide no protection. Let me be precise about what exists and where it exists, because precision in firearms law is the difference between lawful exercise of rights and unintentional violation. The first right that most older Americans are unaware of involves the legal status of recreational vehicles under Castle Doctrine laws. Castle Doctrine is the principle that you have no duty to retreat when faced with a threat in your own home. You can use force, including lethal force, to defend yourself without first attempting to flee. This doctrine applies to your dwelling, and in 38 states, the legal definition of dwelling has been expanded to include motorhomes, travel trailers, and RVs when they are being used as temporary or permanent residences. What this means practically is that if you are living in or traveling in an RV, and someone attempts to forcibly enter that vehicle, you have the same legal standing to defend yourself as you would in a fixed structure home. You're not required to retreat. You're not required to attempt de-escalation before using force. The RV is treated as your castle, and the protections that apply to your home apply equally to that mobile structure. Many older Americans live full-time or part-time in RVs. Many others use them for extended travel. And the majority of them are not aware that Castle Doctrine protections travel with them. They believe that because the structure is mobile, it does not qualify. That belief is incorrect in the majority of states. The structure qualifies, and the protections apply. The second category involves permit fee reductions and exemptions for senior citizens. Concealed carry permits, in states that require them, come with application fees, renewal fees, and in some cases, training fees. 17 states have enacted reduced fee structures for applicants or permit holders over the age of 65. The reductions range from 25% to complete waivers depending on the state and the specific circumstances. In South Carolina, residents over 65 pay half the standard application fee for a concealed weapons permit. In Texas, seniors pay a reduced fee for license renewal. In Florida, individuals over 65 who meet certain residency and training requirements can obtain discounted permits. These reductions are not advertised prominently. They are not included in the standard application materials that most people see. They exist in the statutes. And if you do not specifically ask about senior exemptions or reductions, you will pay the full fee without realizing you qualified for a discount. The cumulative cost over a lifetime of permit renewals can be several $100s. That is not an insignificant amount for retirees on fixed incomes, and it is money that remains in their pockets if they know to ask for the reduction they are entitled to. The third right involves extended waiting periods under specific circumstances. Federal law requires that background checks for firearm purchases be completed within 3 business days. If the check is not completed within that time frame, the dealer is permitted to proceed with the transfer. This is commonly referred to as the default proceed rule. But several states have created exceptions to this rule for older purchasers who have delays in their background checks due to common name confusion, outdated records, or administrative backlogs. In states with these provisions, purchasers over a certain age, typically 62 or 65, are entitled to additional time for the background check to be resolved before a denial is issued. This does not mean they automatically receive approval. It means they are given a longer window for the system to properly process their information before a default decision is made. For older purchasers whose records may span decades and whose names may match those of other individuals in federal databases, this extension can be the difference between a wrongful denial and a lawful purchase. The fourth right is the principle that age alone cannot be used to disqualify someone from firearm ownership. Federal law prohibits certain categories of people from possessing firearms: convicted felons, individuals under domestic violence restraining orders, people adjudicated as mentally incompetent. But age is not a disqualifying category. You cannot lose your Second Amendment rights simply because you have reached a certain age. Several states have attempted to create age-based restrictions or additional scrutiny for older gun owners, arguing that cognitive decline or physical frailty justifies treating older individuals differently. These efforts have been struck down or heavily modified in most jurisdictions. The legal standard remains that you can only be disqualified based on specific adjudications or convictions, not based on demographic status. An 80-year-old with no disqualifying factors has the same legal right to purchase and possess firearms as a 30-year-old with no disqualifying factors. This principle has been tested multiple times, and it has held. Age discrimination in the context of firearm rights is not legally permissible under current federal and most state frameworks. The fifth right involves legacy permit recognition. Many states that now require concealed carry permits previously had different systems. Some issued permits that did not expire. Some issued permits with very long validity periods. Some had voluntary registration systems. When those states transitioned to mandatory permit systems, they included grandfathering provisions that allowed older permits to remain valid without requiring the holder to reapply under the new system. In several states, individuals who obtained permits in the 1980s or 1990s under previous systems are still legally carrying under those permits. The permits are recognized. They do not need to be renewed, and as long as the holder has not been disqualified under current law, the permit remains valid. Many people holding these permits do not realize they have them, or they assume the permits expired decades ago, but the statutes explicitly protect those legacy permits, and if you have one, it is still legally functional. The way to verify this is to contact the issuing authority, typically the sheriff's office or state police, and provide the permit number. They can confirm whether the permit remains in their system as active. If it does, you do not need to go through the process of obtaining a new permit under current law. The sixth right involves hunting license exemptions for senior residents. 32 states offer free or reduced cost hunting licenses to residents over a certain age, typically 65 or 70. These are not limited to small game. In many states, the exemption applies to all hunting activities, including big game. The rationale is that older residents have contributed to conservation funding through decades of license purchases and excise taxes, and they should be allowed to continue hunting without the annual financial burden. But here's the part that most people miss. These exemptions often extend to firearm-related hunting activities specifically. In states where hunting with firearms requires both a hunting license and a separate firearm hunting stamp or permit, the senior exemption frequently covers both. This means that older hunters are not just receiving a discount, they are receiving the legal authority to hunt with firearms at no cost in many jurisdictions. The seventh right is the principle that medical conditions alone do not automatically disqualify you from firearm ownership. Federal law disqualifies individuals who have been adjudicated as mentally defective or who have been committed to a mental institution. But adjudicated is a legal term. It requires a formal court proceeding. A diagnosis is not an adjudication. A prescription is not an adjudication. A voluntary hospitalization is not an adjudication. Many older Americans take medications for anxiety, depression, or cognitive decline. Many have been hospitalized for mental health concerns. Many have received diagnoses that carry social stigma, and many of them believe, incorrectly, that these circumstances disqualify them from owning firearms. In the vast majority of cases, they do not. Unless a court has formally ruled that you are a danger to yourself or others, or unless you have been involuntarily committed, your medical history does not create a legal prohibition. This misunderstanding has caused tens of thousands of older Americans to voluntarily relinquish firearms or to decline to purchase them, believing they are legally prohibited when they are not. The federal background check system does not have access to your medical records. It only has access to court adjudications that are reported to the National Instant Criminal Background Check System. If no such adjudication exists, the medical condition is not a disqualifying factor. The eighth right is the Law Enforcement Officers Safety Act, commonly known as LEOSA. This federal law allows qualified retired law enforcement officers to carry concealed firearms nationwide, regardless of state or local restrictions. The qualifications include a minimum of 10 years of service, retirement in good standing, and annual firearms qualification. But here is what many retired officers do not realize. LEOSA protections do not expire with age. If you qualified at the time of retirement, and you continue to meet the annual qualification requirement, you can carry nationwide well into your 70s, 80s, or beyond. Many retired officers assume that because they are no longer physically active in law enforcement, LEOSA no longer applies to them. That assumption is incorrect. The statute does not include an age limit. It does not include a fitness requirement beyond the annual qualification. It simply requires that you are a qualified officer at retirement and that you continue to demonstrate basic firearms proficiency. Thousands of retired officers over the age of 70 are legally carrying under LEOSA protections, and thousands more are eligible but have not pursued their credential because they believe age disqualifies them. The ninth right involves the repeal of de facto age-based gun bans that were embedded in state statutes. In the 1990s and early 2000s, several states passed laws that created automatic reviews of firearm ownership for individuals over a certain age. These reviews were triggered by medical reports, family petitions, or law enforcement referrals. If the review resulted in a finding of diminished capacity, firearms could be confiscated without a formal adjudication process. These laws were challenged on due process grounds, and in most jurisdictions, they were either struck down or significantly revised. The current framework in nearly all states requires a formal court hearing before firearms can be removed based on capacity concerns. The individual must be present, evidence must be presented, and a judge must make a finding. Automatic reviews based solely on age are no longer permissible in most jurisdictions, but many older gun owners are still operating under the assumption that these old laws are in effect. They believe that reaching a certain age subjects them to automatic scrutiny. It does not. The scrutiny that does exist is the same scrutiny that applies to individuals of any age. It requires due process, it requires evidence, and it requires a judicial finding. The 10th right is the exemption from mandatory hunter education requirements for individuals who obtained hunting licenses before hunter education became mandatory. Hunter education requirements were phased in across most states during the 1970s, 1980s, and 1990s. Individuals who were already hunting before those requirements took effect were grandfathered. They are not required to complete hunter education courses, even if they allow their licenses to lapse and later wish to resume hunting. Many older hunters stopped hunting for a period of years, sometimes decades, and now wish to resume. They assume they must complete the modern hunter education courses, which can involve multiple days of classroom instruction and field exercises. In most states, if they held a hunting license before the mandatory education date, they are exempt. They can obtain a new license without completing the course. The exemption is written into the statute, and it remains valid regardless of how long the gap in hunting activity has been. These 10 categories of rights and exemptions exist across federal and state firearms law. They are not uniformly distributed. They vary by jurisdiction. But they are real, they are codified, and they are available to those who know they exist. The pattern here is consistent. Rights that are not widely known are rights that are not widely exercised. And rights that are not exercised atrophy, not through formal repeal, through disuse, through ignorance, through the assumption that they no longer apply or never applied in the first place. Older Americans represent one of the largest demographics of lawful gun owners in the United States. They are also the demographic most likely to be unaware of the specific legal protections and advantages that apply to them. That gap between what the law permits and what people believe the law permits is where rights are lost without ever being taken. This is not a call to action. This is a statement of what exists. The statutes are public, the protections are available, and the window to exercise them does not close because you were never told they were open.